Hello, my name is Abe Mashney, criminal defense attorney here in Lexington, Kentucky. Today we're going to be talking about the 5 common defenses to DUIs. And so first, let's start with how one is convicted of a DUI. So a person shall not operate or be in physical control of a motor vehicle anywhere in the state. And the most common ways are having a blood alcohol concentration of 0.08 or more while being under the influence, or while under the influence of any other substances or combination of substances which impairs one driving's ability. And so whenever you're looking at common defenses, you're looking at, well, you first start with the statute and work your way from there. So first is, I wasn't the driver. And so this goes to wasn't in operation or physical control. And this is normally a situation where somebody is engaged in a single vehicle car crash where police arrive to the scene later. There's no video evidence or no witnesses. And so there's a doubt as to who the actual driver was. And so number 2, I wasn't in operation of the vehicle. And so again, it goes to operate or physical control. And in this situation, it's normally in where somebody is passed out at the wheel. The car could be on or off, and sometimes it's in a parking lot or on the side of the road, or sometimes in an intersection. And so there is a case called Wells v. Commonwealth. It's a Court of Appeals case that lists 4 factors that the court should look at in determining whether or not there's probable cause that the person is in operation of the vehicle. So I've done another video on that. You could watch that. So number 3, I was tired but not under the influence. And so this is a situation where they don't have a number to point to, whether it was too late or don't have a number within the time frame, the 2 hour of operation, or whether or not the person just refused. And so in that situation, the officer's body cam, the officer's observations, how well they did on the field sobriety test, those are going to play a big part on whether or not that defense of I was just tired and not under the influence is going to be legit. Number 4, the officer administered the test incorrectly. And so what I mean by that is there's standard field sobriety test. There's the walk and turn, the one-leg stand test, and the horizontal gaze nystagmus test. And so officers are trained to perform those and administer those tests standard. And if you don't have a standard way that you're administering those, or if you don't follow the directions, well, then that causes the results of those tests to be invalidated. And so, for instance, when administering the HGN test, also known as the pen test, if an officer is moving his hand or the pen at a high rate or faster than he should, then that's going to create some false positives, and that's something that you could argue. Or if, let's say, there was a leg injury and that prohibits somebody from standing on one leg for a long period of time, or maybe it's raining cats and dogs and it's not a level surface to do the walk and turn. And so those are just some common examples that to invalidate the officer's tests. And then 5th is going to be the suppression issues. And so this is when your client's rights are violated. Your attorney can file motions to get that evidence suppressed. So, for example, observation period. They have to wait 20 minutes in observation before they do the intoxilizer test. And so if the officer walks out of the room or is not observing the person, or if the person is belching or throws up during that 20-minute time, well, that 20 minute has to restart at that point. And if they don't restart it, then the test could be invalidated. Second is reading the implied consent after they take the test and telling the client that they have a right to do a blood test at a place of their choosing. And then third, maybe lacking probable cause for the stop to begin with. And so any trained, experienced DUI attorney is going to be able to spot those issues, file the motions, and be able to argue those to get the evidence suppressed. And so If you're successful in during a suppression hearing, that means that the court is going to exclude the evidence. And because it was wrongfully obtained, the prosecutor can't use that at trial. Therefore, a jury can't hear it or see it. And so ultimately, the prosecutor's office, after the evidence is suppressed, is going to have to make a decision on whether or not they are going to go forward with the prosecution and ask for a trial absent the evidence, or just dismiss the case entirely, or negotiate to a lesser charge. So hope you found this interesting. If you have any questions at all, please give us a call at 859-259-0727. And again, thanks for watching.